pleasure to be with you here all and to be in Xiamen, a beautiful city here in China. My lectures today and for the remainder of the week are going to focus on intellectual property, and in particular, I would say intellectual property at the cutting edge of what is going on today. Yet I understand, unless I have a misimpression, that many of you don't really have an existing background in intellectual property, which makes it a bit of a challenge to go from without a background in intellectual property to the cutting edge issues, because training in intellectual property law, like many legal subjects, is a highly complex field, and when you combine intellectual property with the most advanced technologies, you're really dealing in a very complex set of legal doctrines and rules. So what I'm going to do is I'm going to begin with kind of a brief introduction to the international system, and then a bit of an introduction this morning into the basic forms of intellectual property for those of you who are intellectual property lawyers and have a good deal of background in this that might be a little redundant or repetitive to what you already know, and then move on to the more, I would say, current and complex issues in intellectual property law. And styles of teaching and interaction with students differ in different places. For me, anytime you have a question or a comment or want to argue with me, feel free to just raise your hand and ask a question about really anything at all that you find of interest. So you will see, and I'll show you this in just a moment, and I believe that Guangjia distributed it to you. In addition to the PowerPoint slides, I made available about 9 different documentary readings, and they go into detail about some of the things I'll discuss. And really, if we were going to talk about all of this in the kind of depth, we could devote a semester to most of the kind of discrete topics we'll be talking about. So naturally, we're going to be a little bit thin in what we discuss. So I hope that's clear enough. Does anybody have a question before we get started? And with that, sure. All right. So because you are all students of international law here at the Academy, I think this will be kind of familiar to you, but I think it's very important to start out from the beginning to note that intellectual property is basically a subject of national law. That is, whether you're applying for a patent or prosecuting a patent infringement action or obtaining a copyright or protecting a trade secret, these are things that are fundamentally protected at the national level. They result from the legislatures passing legislation and transforming what might be international commitments into domestic law. And the reason I think it's important to note that or highlight that from the beginning is we have a lot of discussion about international rules about intellectual property or international disputes about intellectual property. And it gives a lot of people the impression that somehow intellectual property is really being governed by these international instruments. And yet, while countries are expected to comply with their international obligations, the day-to-day business of intellectual property is really fundamentally national. And so one of the consequences of that is that different countries will come up with different solutions to the same problem. So over the course of this week, we'll talk about a number of areas in which we're seeking solutions to complicated problems of intellectual property, and to note that China and the United States and the European Union are very likely to come up with different solutions to these problems. And at the end of the day, certainly if you're a business enterprise, you need to accommodate yourself to those different rules. And when we get to actually the last day, we'll go into a little bit more detail about some of the things that create a convergence for these rules. Now, when you look at where these rules come from, the international rules, there's two principal sources. And the older, and going back all the way into the 1860s, are treaties administered by the World Intellectual Property Organization. Now, let me see. Probably many or most of you are familiar with this, but if you're interested in seeing what that's all about, this is the website of the World Intellectual Property Organization, and you can provide a tremendous amount of information about intellectual property at this website. And if you want to actually see what the various intellectual property agreements look like and the texts, you can find those here. And they are in Chinese as well as English, so you can find everything on this website. The WIPO conventions going way back, for example, the Paris Convention on the Protection of Industrial Property established some very basic rules: a national treatment rule, an independence of patent rule, a right of priority rule, and we can talk about what those things go as we go forward. And the Berne Convention established rules with respect to copyright. Paris also deals with trademarks, as well as trade secrets to a certain extent. And so all of these rules remain active. The second source of rules, the separate principal source of international rules, is the World Trade Organization Agreement on Trade-Related Aspects of Intellectual Property Rights, or the TRIPS Agreement. Unfortunately, my browser is blocking the WTO website, so hopefully you can easily enough find it yourself. But what happened with that, just very briefly, is if you go back to the mid-1980s, there was a lot of concern among the industrialized countries, the United States, European, and Japan, about appropriation of intellectual property, particularly by developing countries. And it was thought a stronger common set of intellectual property rules was needed. So we spent 9 years negotiating the TRIPS agreement, or the Agreement on Trade-Related Aspects of Intellectual Property Rights. And then you came up with a sets of common standards. So the Paris Convention, for example, at the World Intellectual Property Organization, was a very minimal agreement. It didn't tell you what a patent was. It didn't tell you what the duration of a patent should be. It didn't tell you the subject matter of a patent. It didn't really tell you what the rights of patent owners were. And so these were perceived as gaps. Right? And so the WTO TRIPS agreement filled in all of those gaps by prescribing common minimum substantive standards of patent law and copyright and trademark and trade secret and design right and geographical indications and other rules. And just as importantly, it established WTO dispute settlement, so an international dispute settlement mechanism, so that if one country thought another country was behaving inappropriately, they could bring a claim at a trade dispute forum to address that. Now, China lately has been quite active in pursuing WTO dispute settlement, but at the same time, and again, we could spend a day about this, but because of the complex relationship between the United States, China, and so forth, the United States has really pulled back from the WTO, and the main judicial body of the WTO, the appellate body, is no longer functioning. So you now have, this has become a simple arbitration system. Right now, for example, China and the European Union, we'll talk on the last day, have been involved in a dispute about something called anti-suit injunctions. But in any case, you have this second set of rules, the WTO TRIPS agreement, and again, because I'm planning to talk more about cutting-edge issues of intellectual property rather than the basic rules. I'm not going to go with you through all of the rules of the TRIPS agreement and how all of that works, but I've provided you some materials that should help you understand that as you move forward. Now, because governments have found intellectual property rules quite contentious, it's been very difficult, almost impossible. There's one area where there was some progress in health, but to reach agreements on intellectual property in a broad multilateral setting. So for the past 2 decades or more, almost all agreements relating to intellectual property have been bilateral or regional, so that we do have some new international intellectual property rules, but they're not at the World Trade Organization. They are in bilateral agreements. And we'll look, again, I think towards the end of the week, the United States and China in 2020 signed the first economic agreement, and that is a bilateral agreement which touches upon what were some very controversial intellectual property fields, and those were resolved bilaterally, not multilaterally at the WTO. And so finally, just to note, and as we'll discuss, most of the developments we witness take place at the national level. The international system regulating intellectual property is always catching up to what the domestic systems are doing, because the domestic systems could move very quickly. It may just be a matter of one judicial decision. But then to take that and get 165 countries agreeing on a new set of rules that's common to all of them is a much different thing. So the international system moves slowly, the domestic systems move relatively quickly, and so we largely focus on what domestic systems do rather than what international systems do. And what we'll be discussing this week, so I'm talking this week about intellectual property at the technology frontiers. We have several areas which we'll be discussing: artificial intelligence, biotechnology, and quantum computing. These areas all are challenging for the existing framework of intellectual property, because intellectual property rules were largely designed to deal with mechanical systems and not necessarily terribly complex scientific systems in the way we have them today. So it raises questions about how existing intellectual property rules are going to deal with these new challenges. That's what we'll be taking a look at. And you'll see that the patent will primarily focus on patent, trade secret, and copyright. and how those are adapted within national legal systems. As I said before, the different systems will reach different conclusions, but for the business community, this is quite common, right? When businesses do operate around the world, we'll talk on the last day, Chinese companies are quite active now in patenting, not only domestically, but internationally. They become the biggest filer of international patent applications. They started slowly in the United States, but Chinese domestic companies are now actively litigating patents and other intellectual property matters within the United States. So the business community is always moving forward. Political systems take a while to catch up, but I suppose one might say that making money is more important to lots of people than whatever it is politicians are doing on a given day. So, and as we look, we'll see that rules are adapting, and we'll discuss how they're adapting. But what we haven't really done yet in any of the systems is taken a real forward-looking look at if we were going to change our domestic law to adapt it to artificial intelligence or to quantum computing or to the most advanced types of biotechnological innovation, what would we do to change our domestic system to make that more compatible with the way that technology has really advanced today? All right. So now I return to the fact that some of you are probably familiar with intellectual property, but on the assumption that many of you are not, I'm just going to start by explaining some of the basics. And I would note, for example, that patents are an extraordinarily complicated field of law. And as I said, it's combining legal systems and scientific information. And quite typically, you can have a course on basic patent law and then an advanced course on patent law before you get into all of the technical details about patent claim drafting and so forth. So this is a very broad overview. But what are patents? Well, they're a form of government grant to inventors to the entitlement of a bundle of rights. And what are those rights? They give the inventor the right to prevent third parties from making, using, selling, offering, for sale, or importing for these purposes the invention. What is an invention? Well, it's a product or a process that is described in the patent and defined by the scope of the claims. And we'll look briefly, I think, I provided for you in your materials one of the patents from Google DeepMind on protein folding technology, and that's just a few of the pages of the patent, but to give you an idea of what an actual patent looks like and what the claims look like, I'll return to that in a minute. The patent generally has a duration of 20 years from the filing of the patent application, though in some circumstances that can be extended. So, for example, in the pharmaceutical sector in many countries, you get a 5-year extension of the patent term to make up for the amount of time it takes the drug regulatory authority to approve a new pharmaceutical product. So you don't have 20 years, you have 25 years, and that is not uncommon. How do you know what is an invention? Well, there are 5 different things you have to look at, and we'll talk a little bit more about this when we get into the specifics. But first of all, the patent must constitute patentable subject matter. There are some things that are not capable of being patented. They are not patentable subject matter, and that's a complex, all of these are fairly complex when you get into the details, and there are 4 criteria of patentability. So you don't just generally ask the question, is this an invention? Instead, you look at these 4 things. And what you look at is first novelty. Now, in each of these cases, I give you two different sets of terms, novelty or newness. In the United States, we use the term novelty. In Europe, you use the term new. So what does that mean? Well, the idea of granting a patent is you give someone a patent on something that's never been done before. Well, how do you know whether something's been done before? You do a search of what's called the prior art. And what is the prior art? It's everything that's been disclosed or sold in the public domain that you can find by doing a search. So the idea of granting someone a patent is you're giving them an award for something that nobody has done before. And you find out whether someone has done it before by searching materials. It happens, there's a fairly narrow rule about newness or novelty, which is you have to be able to find a piece of prior art that discloses each and every element of the claimed invention. So it's not enough that somebody did part of an invention before. That won't disqualify the patent. In order to disqualify something from being patented, you have to find a piece of prior art that discloses each and every element of the claimed invention. The second thing, and probably the most important when you're reviewing, well, I was stepping to this one, non-obviousness or involving an inventive step. I'll come back to utility. Non-obvious or involving an inventive step. Well, what are we asking there? Well, you start by having the prior art, the different things that already exist. And someone comes in and says, I've invented something new. And you say, well, but maybe it just changed a very small thing. Maybe it would have been obvious to anybody that you could change that small thing and call it different than the original invention. So non-obviousness or inventive step involves the distance between the prior art and the claimed invention. So what do patent lawyers do? They describe the prior art, they describe the difference between what they're claiming and that prior art, and then you ask the question, is that sufficiently distant from the prior art that it would not have been obvious to someone reasonably skilled in the art? What does that mean, reasonably skilled in the art? Well, let's say it's a biotechnology invention, and you want to ask the question, is my new biotechnology product sufficiently different from my old biotechnology product? Well, it wouldn't do you any good to ask me, right? I'm not a PhD bioscientist, so asking me if that's sufficiently different isn't really going to help. I have to go out and find a PhD biotechnologist and ask them whether that would have been obvious to them. So you have to find the person who's reasonably skilled in the field. And we'll talk about how interesting this question becomes when we're looking at artificial intelligence in a little while, because this becomes a very problematic set of questions for artificial intelligence. The other thing is utility, or as Europeans say, capability of industrial application. So it's not enough that you describe something inventive, you have to show that you can actually use it for something. And you might say, well, you can use almost anything, so is that an important criteria? This has become quite important, particularly in biotechnology, because today we're capable of generating tens of thousands of variations on molecules very quickly by computer or in the laboratory, but without having any idea what those new molecules will do or what those new genetic strings will do. So it's not enough to say, I just made this new neat piece of DNA code. You have to say, and here's what it does. because otherwise you'd simply be blocking the field. So that means you have to describe utility. And finally, sufficiency of disclosure or enablement. So in the patent application, you have to describe to someone how you make the thing that you're claiming to be invented, so that somebody else can make it, and they have to be able to make it without what we call undue experimentation, right? You can't tell them to go work on a 2-year research program. They have to be able to make it on the basis of the patent application. Well, why is that important? Well, I'll give you an example common to everybody. I assume you're not so young that you wouldn't know what Star Trek is, right? Well, at some point, Star Trek, when the series was first made, and Captain Kirk and the whole clan of Star Trek, they said, well, we've got a spaceship, now we need to get people down to the planet. How are we going to do that? Well, we could have little spaceships that could leave the big spaceship and go down to the planet. And then someone said, well, I've got a better idea. Why don't we teleport them? Why don't we have the transporter, right? So you beam from the spaceship down to the face of the planet. That's a great invention, right? That would change the universe, right? If we knew a way to get people from one place to another by teleporting them. Well, should the producers of Star Trek go on and file a patent application? Well, it was kind of a new idea. It was certainly useful. It was different from what happened before, but what was the problem? Well, they didn't have the slightest idea how you would actually make a transporter. They could describe a neat idea, but to get a patent, you actually have to prove that you can do it, right? So that's the difference between science and science fiction. To get a patent, you actually have to show that you can do the thing that you're claiming. And so you have to enable the invention in the patent application. Now, what is the main benefit of a patent? The main benefit of a patent is it precludes a defense of independent creation. So you can have two companies in a race, let's say a US company and a Chinese company, and they're both trying to create a particular new kind of pharmaceutical product. And they each invest $1 billion in creating this pharmaceutical product. And the Chinese company says on November 1, we have succeeded. We are filing a patent application on this new anti-cancer drug, and they file the patent application. 5 days later, the US company says, we just created the same thing in Boston, and we're going to go file a patent application. They both invested $1 billion. In patent law, there's no prize for second place. The patent goes to the first company that invented, and they block everybody else that could come into the market. So patent law is really a race to the patent office, to the swiftest, and whoever is first wins. And to a certain extent, it's a bit unfair, right? Whichever side you're looking at it from, the Chinese side or the US side, that they both invested $1 billion, but only one of them gets the patent, even though they both came up with the same thing at more or less the same time. But that's how patent law works. Now, there's a narrow exception called prior user rights, but I won't discuss that too much right now. The other way businesses protect information or technology, and this is a very important aspect of protection, is something called a trade secret. And a trade secret is really just commercially valuable information that is not generally known by people in the field that the business has taken reasonable steps to protect. Now, every element of what I just told you is important. It has to be commercially valuable, It has to not be generally known in the field in which it is being used, and the company has to have taken reasonable steps to protect it. So in the old days, most trade secret protection was done just by putting things into a secure building with fences and rooftops, and you prevented people from seeing it. Of course, today we have almost everything is digital, right? So it's much different to try to protect digital information than physical information. So you have more problems with trade secret protection. The advantage, now how do most companies, right, if you go to work for a company, when you enter, when you onboard, they make you sign a non-disclosure agreement, a confidentiality and non-disclosure agreement, that you as the employee promise you will not tell anybody about the technology. So that's a very common thing, right? But you also have the various devices and computer processes that are used to protect information, and that's what protects trade secret. Now, what is the advantage of a trade secret? The advantage of a trade secret is, in principle, it can last forever. You don't lose trade secret protection until it becomes public. And in principle, it becomes public because you decided to make it public. If someone else steals it and makes it public, in principle, you don't lose your trade secret protection. But that's another long story. But so you can have a formula, like the Coca-Cola, almost hard to believe. But they say the Coca-Cola formula for the soft drink is still a trade secret that's been protected for more than 100 years. Personally, I can't believe that no one can reverse engineer Coca-Cola, but anyway, that's the mythology, that Coca-Cola remains a trade secret. The disadvantage of trade secret is it doesn't prevent what we call, I'm sure you're familiar with the term, reverse engineering. So once you put your product on the market, say it's a physical product, a trade secret doesn't protect against someone taking the product, taking it apart, figuring how it works by themselves and making a copy of it. That's reverse engineering. Trade secret doesn't protect against reverse engineering. It only protects things that you can keep secret, which is why people get patents, because patents literally disclose the information, but they protect it. Trade secret protects it, but once it's disclosed, it's no longer protected. So you have these two forms, and we'll talk about that a little bit more. Copyright. Well, you might be surprised that we're talking about advanced technologies. We're talking about copyright because that's something we tend to associate with books and movies and so forth, and music videos. But copyright, if we go all the way back into the 1980s, became commonly used to protect computer software, to protect first the source code of computer software as a form of expression. And when we get a little bit more into AI, we'll talk about how that evolution occurred. But copyright is still used to protect computer software in the form of expression, but it's a little more complicated than that because, as I say, at first it was just protecting the code. It's no longer limited to the code. Things like flowcharts and diagrams and so forth can be protected by software. You have a long term. The TRIPS agreement minimum is the life of the author plus 50 years. Many countries, the term is the life of the author plus 70 years. And there's a separate set of rules for corporate copyright, generally 95 years from the date of creation. But so these terms are long. Now what copyright doesn't do, it doesn't protect against independent creation. Someone makes the same thing on their own without copying yours, they're free to do it, right? So copyright only protects the proprietary interest of the creator, but it doesn't protect against someone else discovering the same or creating the same expression on their own. Now finally, and again, if you follow the field, for example, artificial intelligence, you'll see that this idea of open source. Actually, the source of open source goes all the way back to computer software source code. But so open source. Open source does not mean that it's not protected by intellectual property. Open source, if we take copyright as the primary, means you make, say, the computer program freely available to everybody. Everybody could use it, but it doesn't lose its copyright protection. Typically, open source publishers require that the users comply with certain conditions. For example, you can use my source code, but if you create new source code, you have to give me back a right or give everybody else a right to use your addition to my software. So there's conditions on open source. Or you can use my open source software, but you can't use it for commercial purposes. You can only use it for public purposes. So there's all kinds of open source licenses with very different types of terms and conditions. But the principal thing is that it's not the same as the public domain. When we talk about things in the public domain, these are things that are freely available to everybody. Once something is in the public domain, there's no restriction on it. Open source is different. Open source isn't freed from protective rights. It's just the conditions of using it are open. And you can have open patents, right? It's not quite the same as copyright, but we've seen different ways of companies doing open source with patents. One is called a non-enforcement pledge. The company simply says, we promise not to sue anybody for patent infringement. You can use our patent and we won't sue you. There are also various countries where you as the patent owner can file a special document with the patent office that says anybody can use my patent, but they have to pay me a 3% royalty. So you can open it up, but require a royalty. So there's many different reasons why people use kind of open source patenting, but it's very important in the AI field. So you've probably seen a lot of discussion about things like DeepSeek and Meta and their Llama program and what have you, and people making it available open source, but it gets a lot more complicated than that when you see what they're actually doing. So you have a combination of different ways of approaching this. Well, so let's turn now to some of the issues that come up when we're talking about artificial intelligence. I'll just go back one. So let's start with the first issue I'll discuss of artificial intelligence. And I'll pose it as a question. Can a thinking machine be an inventor of a patented technology? Can you grant a patent to an AI, right? And so typically, well, the inventor is the person who conceived of the invention, right? There's often more than one inventor named on a patent. Typically, those are called co-inventors. They can be joint inventors, but typically, you rarely see patents with only one inventor. There's typically a number of co-inventors on a patent. And then you have to distinguish, it's very important, between who the inventor is and who the owner is of a patent. So inventors are very often people who are employed by companies, by their R&D departments. When they went to work for the company, they signed a document that said anything you invent while an employee of this company will be automatically assigned to the employer. So the owner of the patent, the owner of the technology, is known as the assignee. And they are typically able to actually file for the patent as well. But they aren't the inventor. They're very different things. The inventor is the person who conceived of the invention. The owner is the person who owns the invention. And so that raised the question, can a thinking machine be an inventor from the standpoint of patent law? And this is a surprisingly complex and multi-layered issue, although the practical implications may not be so clear. Well, one thing to start with, having just discussed the difference between inventorship and ownership, is it's generally agreed that AIs, being a piece of computer software or a piece of computer software linked to a computer, do not have a legal personality, right? They are not an organization or entity that can own things, right? We don't let, at least as of now, artificial intelligence entities buy and sell property, right? They are not capable of that. So, however we decide this question of whether an AI can be an inventor, we know that at least as of now, it can be the owner. It can't be the owner of a patent. Now, there was a lot of argument, it's going away, that an AI doesn't have the capacity to autonomously invent in a way that's analogous to a human inventor, right? That AI simply don't have this capacity to be invented. Well, of course, as you well know, AIs first proved themselves to be the best chess players in the world. AIs then proved themselves to be the best Go players in the world. Today, the AIs who were doing Go and chess are now antique AIs. AIs now think in a much deeper and more advanced way than most human beings. And what do human beings do when they invent? A human being, let's say a biotechnologist, is taking all of the information in the field of biotechnology. They're thinking about it. They think, well, how could I change this to make it work better? How could I model it? How could I experiment? How could I come up with something? Well, AIs do the same thing. AIs today take vast fields of scientific literature. They model what potential solutions are to technical problems they're presented with. We'll talk a little bit more about this when we talk about things like DeepMind. They propose various solutions. They model the solutions. They propose what they think are the right solutions. How do you take a folded protein and combine it with a chemical that will bind to the folded protein and prevent it from replicating or somehow otherwise work as a therapeutic for a disease? Well, that's what human beings do. And AIs today are doing it, again, things you've heard. It used to take an individual PhD scientist the whole course of their PhD to create one new model of a folded protein. There are tens of thousands of potential folded proteins, if not more. DeepMind's program modeled every known protein within a space of 2 years. We now have models for virtually every protein we're familiar with that were created by DeepMind. So rather than one scientist working for half their career to create a single model of a folded protein, DeepMind has now created models of them all. And people are working with those models to see how they can be developed into biotechnology products by combining them with other components to see whether or not those are likely to have a therapeutic effect. They're doing it much faster and much better than human beings. So when you ask, can an AI invent? Well, somebody, Dennis Habib, got a Nobel Prize, figured out how to develop the DeepMind program, but he doesn't get involved with the individual questions that are put to the program. The program runs off and does it itself. So to say that an AI can't invent, I don't think anybody takes that very seriously anymore. So I just mentioned this illustration from DeepMind. So is there something that distinguishes what a human does from what the AI does? Because they're conscious? What is it that's different about a human than an AI? If the AI invents something better, faster, cheaper than the human, is the human a better inventor than the AI inventor? Well, that's something to think about. It's an interesting philosophical question, but I would say we've passed the point where we think that AIs can invent. But so why then is it important? So now the AI, now DeepMind, the computer program, develops a new pharmaceutical product. Now we're filing a patent application. Well, who invented the pharmaceutical product? Well, was it the original person who wrote the program for DeepMind, even though they haven't had anything to do with this particular inventive activity? Someone simply told the AI to go out and try to fix this particular problem. So unless you're naming the AI and the inventor, who is the inventor, particularly whether it's a sole inventor? And why not name a human as the inventor, even though it was an AI? Well, simply because you're misleading, you're lying to the patent office. You're not allowed to lie to the patent office. If you say a human invented it when an AI invented it, you're telling the patent office something misleading. So the European Union, for example, has said, well, you can't name the AI and the inventor, but in the specification, the written description of the patent, you can tell how it was developed by using an AI, even though you've actually got the invention assigned to the company that owns the AI, right? So the typical solution is we give the patent to the company that owned the AI which created the product, even though we know that that company didn't actually create the invention. So it's something, we'll call it, of a fiction. Why have policymakers said, well, we don't need to give AIs patents? Well, why do we give people patents? We say we give people patents because it encourages innovation, right? If you're a human being, I assume most of you are, none of you look like robots, why do we offer you a patent? We do it as a reward, right? We want you to create something, we'll give you this right to make money through the grant of a patent, and therefore we're encouraging innovation. Why do we give a pharmaceutical company a patent? Because they invented $1 billion to create the drug, and unless they have the protected market, they're not going to invest in creating the drug, therefore we give them the patent. Well, then you say, are AIs motivated by making money? As far as we know, they aren't. They certainly do make a lot of money. Most of the financial trading going on in the world today is being done by AIs, but it's not because they're motivated by making money, it's because someone told them to make money. So do we really need to give an AI a patent to motivate it to invent? Well, the answer to that presumably is no. But we do have to give somebody an incentive to create the AI and to make it do what it's doing. So presumably that's the reason, so the reason against giving an AI a patent is because we don't need to suffer the economic impact of the exclusivity, but maybe we need to give the AI the patent because we need to give the incentive to somebody who's paying for it to do the work. So it's a complicated subject, one that naturally only comes up because we now have artificial intelligence, right? So can we give an artificial thinking machine a patent? Now, this person probably, you might say, well, there's some resemblance between him and me, but was I ever that young? Well, that's because that's my son. That's Ryan Abbott. And my son is one of the leaders in this area of AI and inventorship and AI and intellectual property, and that's him testifying before the US Congress. And so the other thing is, well, I'll start just with this observation. So let's assume you're not going to give an AI a patent. Can an AI be a co-inventor? Should be included on the application along with a human? Humans have used computers, for the past 50 years to help them invent. Can we just say that the AI assisted the human in creating the invention? And when do you have to disclose that? So, as I noted, so far courts have not been willing to recognize AIs are inventors. These decisions have almost exclusively been based on statutory language. So if you look at this case, and it's in the materials you got, this was the U.S. Court of Appeals for the Federal Circuit, said that no, the statutory language of the U.S. Patent Act, not directly, but suggested that inventors have to be individual human beings and not AI. So the U.S. Patent Office didn't allow that. The only country that's allowed an AI to be an inventor is South Africa, but bear in mind that South Africa doesn't engage in a substantive review of patent application. This, by the way, is my son holding up the inventions made by the AI that was issued in this case. If you look at that case, you'll see he was representing the AI creator in that decision. Now, right now, including in China and the United States and the European Union and Japan and everywhere else, patent offices are trying to figure this out, right? What should we do with AIs? How can we name them the inventors? If we don't name them the inventors, what do we do? Do we ask people to lie to the patent office, even though they didn't invent it, and tell us that they did invent it? And what kind of new rules can we make that actually make sense? Because everybody agrees that none of these laws were drafted with the idea of AIs in mind, right? So to say that they don't cover AIs right now is just to say kind of the obvious that no one thought about this when they were drafting the patent acts. Now they need to think about it. So that's where we currently stand. Now, actually remarkably well, we came in almost exactly at the right time with that. I surprised even myself. So we'll get on to lecture 2 when we resume. Is that right, Kwanjia, that we're finished with the first one? Time-wise? Do we take a break now? Yes, I think so. No one will answer me. So, time for the break? Yeah? Ready? 10-minute break. All right. So, see you in 10 minutes. Oh, pause. I thought you said post. No. Yeah, speaking pause. Good idea.